give some insights into their respective jurisdictions' specific frameworks. As you have seen from the invitation, today's program foresees 5 presentations for our 5 distinguished speakers. I will get to the details of the presentations in a minute. I just have to give a couple of housekeeping rules up front. This webinar will be recorded and it will be available on the ICN website afterwards. The presentations will be one after the other, and there will be a Q&A session at the end. You will be able, as it's also indicated in the slide that you see on the screen, you will be able to put your questions in the chat, please. So there is no option to pose questions orally for a matter of organization. And I would also ask you, as per the ICN rules, not to use any AI tools to transcribe or summarize the webinar, please. So without further ado, I would like to start. We can start with our presentations. And the first speaker of today is Mr. Jonathan Zwickel. Jonathan is the Deputy Chief Legal Counsel for Civil and Administrative Matters at the Israel Competition Authority, leading a team of lawyers. He previously served as a team leader at the ICA's legal department for several years, and he was also working at the OECD in the past. So, Jonathan, please, the floor is yours. The floor is yours.
Thank you very much. It's a real pleasure, really a privilege to be speaking to you today. My aim is to maybe try to put a smile on your face, or at least evoke some emotions with my presentation. I will try to show you that stories and evidence that tell stories can really boost your case. So if we can start from the first slide, I'd appreciate it. If we can move to the next slide. Next, thank you. So the first story I want to tell you is about the first case I ever had to prosecute as a team leader. And it was a really easy case, to be honest. There was no question about the dominance of the firm involved. It was very clear that its competitors were completely reliant on the services that that dominant player was providing. They really couldn't do much without its services. I had a good witness. The witness was a member of the management of one of the competitors, and I also knew what he was about to say in court because I had the opportunity to interview him. In fact, the interview was conducted in the presence of the counsel for the opposing side, with the counsel for the firm that was under review, and I knew that he was going to say that our intervention improved the situation in the market, that thanks to our intervention, the monopolist was more open, more receptive to requests, the services that were provided were better, more timely, and so on. And still, I was really scared, because this was the first time I went to court as a team leader, and I felt like the whole weight of the case was on my shoulders. And I wasn't 100% sure that I would get the answer that I wanted. I was prepared with my notes, and I was prepared, like you have to prepare for cross-examination, with the response that you hope to receive, to corner the witness. But I was still scared. So if you could move to the next slide, please. The key point I want to take from this story is that while we're all different, we're all from different jurisdictions, we come from different backgrounds, the economies that are different. I really can't state how different things are in different places around the world, but we also feel the same when we come under scrutiny, when we are the face of the authority or the agency, and we have to prove our case to court and really be under review. So for me, at least, as personally, and also as part of our DNA as an agency, as an authority, I'm sure other agencies share the same kind of DNA. We see every case as if it's going to court. For us, this means we have to be prepared from the first day. And it starts with the collection of evidence, and I would be happy if you could move to the next slide. So you can be creative in uncovering evidence, and we had the opportunity to literally uncover evidence in a very creative way, and I'll tell you about this story that revolves around conduct by our local telecom monopoly. Now, I just want to clarify as a disclaimer that I'm telling a story. I'm maybe not 100% accurate with the details. So if there are any, I don't know, people interested, please know that it doesn't necessarily reflect the exact details of the case, but still, the gist is true and real, and I hope you can learn from this. So here was a situation where we had a monopolist that had control over the access of competitors to what we call passive infrastructure. Passive infrastructure is really the manholes and the ducts and different types of infrastructure through which telecommunication cables run and are connected to endpoints and so on. And the competitors had trouble accessing that infrastructure, which was controlled by the local monopolist, who was forced to grant that access under regulation by our local laws, telecommunication laws. And one of the arguments, not necessarily the most important argument, but one of the arguments put forth by the monopolist was that it was not self-preferencing in any way. That it was arguing that the way things were set up for competitors was identical to the way it was set up for the monopolist. The same connections, the cables were cut and connected in the same places. Everything was the same. We weren't sure about this, so we asked. We had 1, 2, 3, maybe even more RFIs, interviews, discussions with the company, and we weren't sure that we were getting a straight answer. They were adamant that they were treating their competitors fairly and equally, and that everything was the same for all the players in the market. So we had to check, we had to see with our own eyes. And what we did was we decided to have an inspection. Now, this was an announced inspection in the sense that they knew we were coming, but they didn't know exactly where we were coming. See, we told them that we were going to meet them at a certain point, and that only on the morning of the inspection, we would tell them where exactly we wanted to visit. And these were basically manholes, you know, these holes in the ground that need to be opened up. And when you enter the manhole, you can see with your own eyes how things are connected. And once we uncovered the first manhole, it was clear that they were lying, or at least, let's be more modest, let's say they weren't exactly accurate. The colors of the people present, the faces on the people present changed color. So if you can be creative and surprising and have interesting ways different ways to inspect, use them. Go to the next slide, please. Next slide, please. Okay, so no, I think you skipped one. Sorry. Yeah. Okay, so very important. I believe from my experience, I'm sure all of you will agree that being interesting is very important. I'm not saying in any way that other types of evidence are not interesting. They're interesting. They're maybe even more important than the type of evidence I would give you an example of right now. But still, being interesting is like the cherry on top of interesting evidence is like the cherry on top of the evidence cake, if you wish. One example of this comes from a case involving our local light beverage supplier monopoly or dominant player, who had different types of policies that were designed to maintain its customers, its clients' loyalty. We were able to obtain a conversation between a one of the monopolists clients, and an agent for the dominant firm. And the client was discussing the possibility of maybe purchasing some of its beverages from a different supplier, from a competitor. And this is part of what he was told. If my manager hears you, listen carefully. If he hears you, he will cut your tongue. He will cut your tongue. That's what he was said. Now, you don't have to have a dominant position to use that language. I mean, it's not a very nice language. You don't have to have a dominant position to use that language. But if you have that type of evidence, and if you add that type of evidence to other types of economic evidence, I don't know, um, uh, market share or um, different things like empirical analysis, other types of internal documents. If you have that interesting story that you can show the court, or just the general public who reads your decision, it's helpful because it really gives the sense of how things really work, what market power looks like, what it smells like, what it feels like. Can you go to the next slide? Finally, we go back. Last story, we go back to the telecommunications sector. Same case. Here, we had another. We had the need. We needed to figure out the technicalities of how this sector works. It's very complicated. How cables are connected, how they run, how they're laid out, how they're spread throughout the country. Different, very complicated technical questions. And we had very long interviews and discussions and RFIs. In one of the discussions we had, which lasted about an hour or an hour and a half, we asked technical questions. And after being asked one of the questions, the representative for the dominant firm, they asked to confer amongst themselves and to mute the conversation. Several minutes afterwards, they came back with an answer, and their answer was more or less, listen, you guys don't understand how the sector works. Your questions show that you don't understand how cables are connected, how the market works. You don't understand anything. We'll tell you how things work. And the conversation went on. And so we were not convinced by their responses. And after a while, we fined them and we ended up in court. And in court, there came the time to cross-examine one of the representatives of the company that was on the call, who was on the call. And that representative was asked about the call. And he kept more or less with the same line of answers. You don't understand how this market works. This is not how you connect things. What you think, the way the competitors argue the cables should be laid out, it's wrong. That's not how you do things. Well, something very interesting happened. See, after we had that conversation years before, we, as we always do, sent out the transcript to that company and asked them for their remarks. And they gave their remarks back just to make sure that we had written everything down correctly, that we had a good record of that conversation. And their remarks were so specific that we had a feeling that the conversation was recorded. So we asked for the recording and we got it through an RFI because we have the power to do that. And what was very interesting, what was discovered by the case team, was that the entire conversation was recorded. Not only the part that was heard by the authority, but also the muted part. And then we heard that they knew exactly what we were talking about, and that the response was formed despite their using technical terms that made it very clear that our questions were very good questions, that they reflected an understanding of the market. They still continued on with their line of trying to argue that we don't understand anything. Well, when we arrived in court, we saved that. We didn't write that in our decision. We saved it for court. And when we arrived in court, we brought a new part of the transcript to court, and we presented it to the judges right before playing that part, that muted part, to the witness. And I remember the smiles on the judges' faces when they saw the transcript, because they saw that the credibility of the witness that was sitting there and telling them that the authority doesn't understand anything was really in shatters. So this was a big victory. Now, again, not necessarily the most important point in the case, but think of what this does to the authorities' credibility, to the opposing side's credibility, and also maybe something that we often overlook. But this story and the other stories are as well. They build morale. They're good for the team of lawyers and economists who work together. They help us form our stories around our cases around these stories, and it's very helpful. So if you can go to the next slide, I will conclude by saying that if I learned anything from our experiences, that it's always good to spice up your evidence and the presentation of your case with these kinds of evidence. It's not necessarily enough. It's usually not enough to win your case. You need the numbers, and Pascal, I think, is going to discuss this in just a short moment, but you can't build your case without the proper sound economic basis. And behind all these stories was, I promise you, you'll have to read the cases for yourself, but we had sound economic analysis. But these little stories, these cherries, were really, really helpful, and they make everything more relatable and more lively. So good luck trying to find those. I think that's it for me for now.
Thank you very much, Jonathan, for this very lively and interesting presentation about your experiencing in uncovering literally evidence in various scenarios. We are moving on now to the presentation by Pascal Deschamps. Pascal is a competition economist and now is currently a partner at Accuracy. It's a consulting firm specializing in financing and economic analysis. Pascal used to be formerly head of unit at the French Competition Authority when she oversaw antitrust cases in digital and telecoms. And today she's going to talk to us about the successful use of economic evidence in unilateral conduct cases. The floor is yours, Pascal.
Thank you, Vera. And Jonathan, I have to say, we do try to be interesting, though some people would argue the numbers are boring. Not sure it's lovely, but it definitely can become lively when you do have economists in the same room. So I'll come to that in a second. If you can get us on the first slide. Yes, so these are the topics I'd like to cover today. If I don't get to the third part, I thought it'd be good to just leave it in the presentation for other people to refer back to it in case there's interest in these topics. I mean, I guess the first point is, what is economic evidence? And then is, what shape does it take and how do you get it? And then what you, of course, do with it. But typically those first stages can be quite essential in building the evidence in a unilateral conduct case. You can turn the slide, please. So economic evidence, I think, it can be, in a way, market share is an economic indicator, right? So almost some of the basic figures we use in unilateral conduct cases. It can, of course, become very sophisticated economic analysis with theories of harm, with econometrics, though typically not as frequently as in merger cases. But you can have some analysis of effects of anti-competitive practices that can be fairly sophisticated. However, it's my firm belief that the really key input of economic theory is in the framework, is in how you think about firms' behavior in a way that actually makes economic sense. So where the law is form-based, the economic reasoning is typically effects-based and grounded on market behavior. And if you combine the two, you reduce the risk of over-enforcement or under-enforcement. So two different conducts from a legal perspective can lead to the same economic effect, that is foreclosure of competitors, for example. But also the same conduct from a legal perspective can actually have different economic effects depending on the market circumstances. So it's by combining the two elements that typically one can come up with the best assessment of the situation in one market. So economics can help provide educated presumptions and pointers that can help determine where to further spend efforts in the investigations and uncover internal documents or ask for market information. So we have a sort of toolbox that helps understand market outcomes and firm conducts. Now we use it in the various steps of an assessment of a potential infringement of competition law in terms of unilateral conduct. You can use it in market definition and the assessment of market power in the first stages, and then in how you assess the actual practices. So I'll come to this in a moment. Can turn on to the last slide. So the types of economic evidence. So you have, on the types of economic evidence, you have two types, basically. Some of it could call it the raw data. It's not really raw because typically it's already been processed, but we're talking about numbers. So market shares, prices, range of products, number of competitors, this kind of information. Economic evidence can also be how you actually frame that information, that data, into a coherent assessment and a coherent framework. So that's where you get the economist reports, typically from companies like mine, but also from others, and from chief economist teams, typically within competition authorities, for those that have them. It helps articulate the theory of harm in legal submissions and ensure the consistency of the reasoning, the legal reasoning, with the actual facts. Now, economists disagree, like lawyers. The economics is not a hard science. So economic evidence, they combine with other types of evidence, and in particular internal documents. It's going to be the topic of one of the other panelists later. If you have disagreements among economists, it can come from two reasons. The first one is they disagree on the facts. And I think the answer is figure out what the true fact is, right? And make up your mind as to what you believe is the actual true fact. So is the market share 32% or is it 45%? Depending on the type of information you have, you might believe it's the former or the latter. If the disagreement comes from how to interpret the data, then it's important to check the framework and assess what sort of assumptions are being made within each of the frameworks, and then come up with your own assessment as to which one you believe is the right framework. And I think this is where the economic theory is the most powerful, is to unpack this mechanism for anti-competitive harm. Now, how do you gather economic evidence? When you have a complainant, not always the case, but when you have one, typically they'll be the first to provide information, not necessarily much of it or not necessarily framed in the right way, but they are typically the companies that you can then ask for further information in a way that you believe is the better way of framing it. There are biases, and they have their own interest at heart. And one of the difficulties with the complainants is that they'll tend to tell you that all their problems come from an abuse of a dominant position or from a unilateral conduct. And in the end, the economics can help you parse what is the result of potentially that conduct from what is the result from a lot of other things that may have happened to that company. But the complainant will, of course, try and load their complaint with everything they can think of that will be caused by the unilateral conduct. Now, of course, you can get economic evidence from the defendants through RFIs, potentially don rates. We'll come to that also in a minute. Internal documents can contain relevant information, of course, board minutes, marketing presentations, business unit performance reports, etc. They'll have the opposite bias, which is, first, we're not dominant, and second, whatever we've done, it's not our fault if the market is where it is, and in any case, it's not so bad, right? So that's the sort of the opposite perspective that you'll hear, but possibly with economists on both sides, as I was saying earlier. And the question is, how do you parse through the information in a way that you believe is the appropriate one? You've got information from public sources, and I cannot emphasize enough how important this can be in cases to avoid the biases that come from the fact that information might be coming from an interested party. The interest of public data is that it's not interested. If the problem is, it might not be very good. So you have to basically balance the fact that it's available, publicly given, with the fact that it might not be exactly what you're looking for. And there I'm thinking in particular in terms of the market definition, It might not actually give you the exact numbers you're looking for, but it's better than possibly relying on a best guess of someone who actually has a vested interest in providing you the information. And then, of course, there's the creation of economic evidence, as in the framing and of the evidence done internally within competition authorities. So either from chief economist teams or economists within case teams. And there, it's really key to triangulate, that is cross-checking information, and ensure that there's a consistent framework for the information that is being provided, whether it's numbers, but also internal documents. How do they speak to one another, and how does it work, economically speaking, that it all makes sense? If the company, in most frameworks, at least in Europe, we don't actually have the notion of intent. So we don't actually care whether there was an intention to do something that would be particularly bad. But if there is strong evidence of an objective justification for the practice, I think we would also want to ensure that we take that into account to assess whether at heart that practice was not actually anti-competitive and was unlikely to lead to anti-competitive effects. Can you put the next slide, please? So, and I'll go briefly over these slides, and you can refer back to it if you want. But as I was saying, you can use economic evidence in defending markets and assessing the extent of market power. In assessing markets, if there's one thing to remember, is market definition in unilateral conduct cases can be very strongly subject to significant technical challenges when you use standard systems that you might use in merger control, because the market is already subject to market power. And so typically when you look at substitution from the part of consumers, consumers will tend to go away from the dominance from products more easily when there's already market power than when there is competition. So typically the dominant company will try to argue that the market is wider than it what truly is if it was a competitive market. It's called the cellophane fallacy from a DuPont case back in the US a long time ago, but which showed that actually, if you get the market definition wrong in the unilateral conduct case, as everyone knows, as soon as you're not dominant, of course, the whole case collapses. So the market should not be defined too widely using poorly some economic tools. When it comes to market power, just a word of caution around market shares. I think it's the job also of economists to say this is just not one magic number. It's not because it's 50, then suddenly we have many problems, or even 80%. It's one of the elements that determine market power that needs to be taken in the whole with the rest of the market information. I personally prefer to consider it a safe harbor when you're small enough, then consider it as a very strong presumption of the existence of dominance when it's large. Basically, you need to combine it with other types of evidence, depending on market circumstances. Can you move on, please? Ability and incentives to engage in a particular conduct. So this is now, in Europe at least, the typical language to determine how to go around assessing whether a unilateral conduct is likely to have anti-competitive effects ultimately. And this ability and incentive is really grounded in the economics. And there, maybe the one point on this slide is, we assume companies are profit maximizing. And that may sound obvious in a way, but actually that is a very strong assumption in some cases, because you might actually have companies that are not profit maximizing. And also it has all kinds of consequences as to how they're going to behave. They will not engage in a conduct actually will not lead to profits. The question is, these profits might actually be later, in the typical case is predation, or it might actually be in a different market. The case of leveraging, when I'm large in one and I'm tying a product, I'm using my dominant position in one market to improve my competitive position in another market. So it's a very strong driving force of firms' behavior and also of the economic framework that we apply in unilateral conduct cases. Maybe I'll move on to the next slide, please. And then finally, the last two steps, I think, where economic evidence really plays a big role. First one is on objective justification. I mean, at least in Europe, you can, try and argue that your unilateral conduct wasn't so bad because actually you had an objective you were trying to fulfill. And this is the least intrusive way of achieving the objective, right? So the test is that you need to prove that the conduct was necessary and proportionate to achieving the objective. And, basically your consequence is that you couldn't find another way that would be less damaging to competition than this way of achieving your objective. And in fact, there, it's really the articulation of what is that objective justification. Typically, it's of an economic nature. So if you think, in vertical cases, of course, it can be quite straightforward, as in I'm trying to incentivize my retailer to make some investment, so I have a guaranteed exclusivity with that guy. If the company is small, no one would care. In fact, it's well understood that it's efficiency enhancing. But in the case of a dominant company, especially if it's done with multiple retailers, it can end up completely foreclosing the market. Testing the underlying rationale for the objective justification is essential, and typically their internal documents are going to be your best friends, because if the internal documents don't say anything about the objective justification, then it means it's made up after the facts. Basically, they are justifying the conduct after you've basically started arguing it's anti-competitive. And then that's, at least in my opinion, an easier case to then prove it's anti-competitive, even if there was no intent. And then the last bit, of course, which is where possibly most economic analysis is done in unilateral conduct cases, is what were the effects? At least potentially. In Europe, we have these potential effects thresholds. You don't have to prove everybody's dead, but you do have to prove it could have killed someone, okay? And in fact, it's not a theoretical standard. If there was nobody to kill, there's no abuse, okay? Because we've had a couple of cases actually in Europe where the courts have said, hang on guys, yes, this is potential, this is foreclosing, but there's no one to foreclose. So where's the problem? So I think it's something where really economic analysis can really help understand the market mechanics that will then lead to actual foreclosure or exploitative abuse in the case of exploitative conduct. So I think this is a fairly quick overview, but I'm happy to take questions at the end as to how economic analysis can be used in unilateral conduct cases. Thank you.
Thank you very much, Pascal. We are now moving on to the third presentation. Is from Mr. Bhatia, who's an NGA to the Competition Commission of India. Mr. Bhatia is a senior legal advisor of the Competition Law Practice Group and a former additional director general at the Competition Commission of India. Currently, he represents cases before the Competition Commission, before the Appellate Tribunal, and before the India's Supreme Court. Please, the floor is yours.
Thank you very much for the opportunity. It's a privilege, and I'm happy to share along with the other esteemed panelists. As you know, next slide, the Competition Act 2002 came into force in India on 20th May 2009. In the journey of 16 years of enforcement of the law, Competition Commission of India has dealt with over 1100 cases. But as you know, the jurisprudence is ever evolving, and the economic and market conditions, they are equally they are dynamic, they are getting changed. And so is the case of the law and the procedures. This one fundamental principle is that conduct of an inquiry, holding of an inquiry is a precondition before the regulator can pass an adverse sanction, cease and desist order, or impose penalty on a dominant enterprise. And it is based on a fundamental principle that no one should be condemned unless that party is heard. And this unilateral conduct of inquiry involves 4 steps: that the charged party is an enterprise. Enterprise must be dominant in the relevant market. It indulges in one or more of the abusive conducts which have been prescribed in the law. And then this 4th limb, it has appreciable adverse effect on competition, on market, or on consumers. This 4th requirement, adverse effect, for which the earlier panelists have spoken about economic analysis and all those things. It has only recently that the Supreme Court of India has said that the CCI must also look into appreciable adverse effect dimension before condemning a dominant enterprise, because dominance per se is not bad, it is only abusive conduct, and now that abusive conduct must result in harm to competition, harm to competitor, or harm to market. Only then you can frown upon a dominant enterprise for unilateral abusive conduct. Now, for that, the procedure is that CCI has to form a prima facie opinion, and there is an agency by the name Director General who is armed with all powers to investigate into the matter. So formation of prima facie case by the CCI is a precondition, and thereafter the investigation set into motion. The Director General, being a statutory officer, he is blessed with the power to call for information. He can summon the person, he can record evidence on oath, and he can also requisition the public record, etc., to fulfill the case, to collect the evidences, etc. Now, where there is a suspicion that the charged party may not furnish the information, or the information may be destroyed, evidence may be destroyed or mutilated, the Director General can approach the Chief Metropolitan Magistrate to undertake unannounced search and seizure. And it is only after convincing the Chief Metropolitan Magistrate, Delhi, that the DG is authorized to go for an unannounced raid, unannounced search and seizure. DG can, but though these all statutory rights are vested in DG, but in order that the inquiry is fair, the investigation is due process is adopted, there are certain obligation also on the Director General that he must undertake and complete his investigation by adopting principles of natural justice. That means fair opportunity must be given to all parties while recording, while collecting evidences. Next slide, please. So as I mentioned, dominance is not per se bad, and dominance is not assessed merely on market share. So we do not have any arithmetical threshold. Dominance is in addition to market share. The Competition Commission is mandated to look at size and resources of the company concerned, size and resources of the competitors, the commercial advantage over competitors, the extent of dependence of consumers. Is it a public sector or government company? Do consumers have any countervailing power or not? And economic contribution. So these are other 13 factors in addition to market share, which are required to be seen before determining whether the entity is dominant in the relevant market or not. Then after assessing dominance, it also that dominant enterprise must adopt one or more of the abuses, and those abuses are prescribed in the law. And those abuses are: is it that the dominant enterprise is indulging in unfair pricing or discriminatory conditions, or is it limiting production or supply of product? Is there a case of denial of market access in any manner? Is it that the dominant enterprise indulging in contracts subject to unrelated obligations and leveraging of dominance in one market to protect or enter into another market? Only if the dominant enterprise indulges in one or more of the abuses which are mentioned in the law, only in that eventuality uh, the Competition Commission can pass adverse order against the dominant enterprise. And collection, so coming back on the real topic is that what is the challenge and what type of documents are required. So unlike anti-competitive agreement where there is a presumption, where there is a per se illegality, especially in case of cartels, since dominance is not per se bad, so collection of documents, collection of evidences becomes more relevant compared to a situation when the inquiry relates to anti-competitive agreements. Uh, Now, collection of the documents and information, once the prima facie order is received in the office of DG, so DG allocates the matter to a particular one of his junior. The junior is assisted by a team of officers, which can be chartered accountant, which can be cost accountant, which can be legal people, or from the finance experience and education. So a team of officers look into it and they evolve a probe notice. What kind of information should be collected so that the Director General is able to give its report along with finding with supporting evidences. So the size, scope, and what type of question should be asked is a very, it's a case-to-case basis. It's very difficult to, I mean, one size fits all. That policy uh, cannot be used in case of investigation into unilateral cases. Next slide, please. Next slide, please. So ordinarily, in relation to investigation into unilateral conduct, the charged party is asked about the market share, the product-wise details of competitors, details of upstream and downstream market, list of customers, email dumps, copies of communication, agreements with verticals, price list, details of sale promotion schemes, including details of board and key managerial person, and such other specific information depending on the charge. If the issue relates to predatory pricing, obviously the question will be in relation to price and cost. In case there is a allegation relating to denial of market access, so how that denial of market access is being taken. And I will give you a one classic case which I handled. There is a company which is marketing cancer related medicines. A biosimilar company came up with a similar product approved by competent authority, and that the existing dominant player started writing communication to government health department that please don't use the other biosimilar medicines. You are doctors, you can be subject to uh, uh, various types of problems, and hence we suggest don't recommend that medicine. And so it is a denial of market in any manner. So scope was defined, and it was found that prima facie it looks like denial of market access. So in order to ensure the parties to share commercial sensitive information in India, we have got a uh, sound confidentiality regime, and the information which has got commercial sensitivity, that information is masked. Third parties and statutory authorities are can also be asked to furnish information, and they also have got the liberty to ask for confidentiality. In case a party does not cooperate, in case the party does not furnish complete information or gives evasive answers, that the penalty provisions gets triggered, and in the recent amendment the quantum of penalty has been geometrically increased. Now once the information is collected, then the process of review and analysis of documents commenced by the Director General. So in the first instance, the while reviewing the document, the relevant documents, relevant information is segregated, and they are converted into in the reviewable format so that the entire team investigation team can look at it, and at the same time since the investigation is conducted under the control and superintendence of the Director General, he is also able to scan, go through, and review the documents. So, factual claims as per the information furnished are compared, are verified, the veracity of the information is audited with reference to information available in public domain. The company must have filed several returns, several information with the statutory authorities. They must have issued, they might have issued press releases, or their internal documents like annual accounts where board of director report is there, or chairman's speech is there, or some statements by key managerial persons are there. They are cross-checked from them. Also, the information is cross-checked by pulling out information from the third party, from the verticals of that charged party, so that the information which is examined meets the requirement of the Competition Commission of India. Many a times voluminous records are are handed over to DG, and review process becomes very difficult. For that, the Director General avails of the services of an independent forensic experts, and recently the Competition Commission empaneled several agencies which are having expertise in forensic check. They have been empaneled by CCI, and so there are certain requirements on that. On the forensic expert, forensic expert must be independent, must not be conflicted with the charged party, and more than that, the forensic expert must be able to become an expert witness before the Competition Commission if need so arises. Next slide, please. So we come across, the investigating arm, and we as practitioner, as a defendant counsel, or as a counsel for the informant, we comes across several type of challenges about the collection of documents. Many a times there is there is no formal documents. Now, if in the absence of formal documents, how the person concerned, how the Competition Commission or Director General can prove the burden of that there is an evidence that there is some abusive conduct on the part of the charged party, or the contents are ambiguous. They are based only on informal understanding. There is no formal document, or documents lack clarity, or it is subject to certain red flags. That means some minor changes with hand have happened, and so the true interpretation of the document is not possible. The the collected document may lack authenticity. Many times we come across a draft agreement which is not signed by the parties. Know how to take it that as if there is any understanding or not. Many times there is document, but there is some kind of evidence in relation to meeting of minds, but it is seen that there is no human intervention in that. We also face the problem of legal professional privilege, and that privilege is there. But recently, the Competition Commission has overcome this problem. No doubt, the practitioners, lawyer in practice, they are the communication between client and the practicing lawyer is privileged. No one can have an access to that. But in-house counsel now can be summoned by the Director General to prove the veracity of the evidence which is tendered before the Director General. Data privacy challenge also, to a large extent, we have been able to deal with, because recently the Appellate Tribunal has passed an order that in case data is data is there and data practice is used and give rise to competition concerns, then data board can also look at into it. But so far as competition dimensions flowing from the data privacy provision is concerned, that can be looked into by the Competition Commission of India also. So the jurisdiction has now been solved that in case data privacy practice leads to any anti-competitive or abusive conduct on the part of a dominant player, then CCI has got jurisdiction to deal with that aspect. Next slide, please. Now, what are the best practices which Competition Commission in its journey of 16 years enforcement journey, what best practices we have been able to adopt are that key managerial persons are examined on oath. Many a time documents don't speak, do not, we are not able to unearth or the documents do not reveal that there is an abusive conduct on the part of charged party, but that is cross-checked and the key managerial persons of the charged party can be examined on oath and deponent is asked questions in relation to documents, whether they are formal or if there is any understanding or arrangement, information can be sought, and the deponent is clearly told that you are on oath, and in case you are giving any false information, you can be prosecuted under the criminal law also. And interestingly, recently the recent regulation says that deponent, when he's recording or giving his statement before the DG, he can't be accompanied by an advocate. So it will not be an influenced one. It will not be a doctored statement. So it will be an independent and a statement which is coming from the core of the heart of the deponent that is recorded. That's the best part of the recording of the evidence in India. The amended law now empowers the Director General to call in-house counsels. Generally, counsels are not, they enjoy the privilege, but in case you happen to be an in-house counsel, now there is power in DG to check the veracity of any document. In-house counsel can be called. In order to maintain the secrecy of search and seizure, there is a power with DG to go far, but it can be exercised only with the permission of Chief Metropolitan Magistrate Delhi. Hitherto, under the MR monopoly law, the power was in the district court of the place where raid is going to take place. Now it has been specifically provided that only power or permission of search warrant can be given by CMM Delhi. So this is only to help in maintaining the secrecy of unannounced search and seizure. Similarly, submission made by the charged party and KMP. This is an internal process which has been adopted. Hitherto, we as lawyers used to sign on behalf of the company, which is filing the information before the DG. In its recent practice now, it is not the advocate who signs the document, it is the party or the key managerial person of the charged company that he signs and authenticates and verify the information which is filed before the Director General for investigation purposes. Next slide, please. Yes, there is a dimension of artificial intelligence. I will not go through this slide, but I can only mention that in order to have better understanding in relation to artificial intelligence and its use by the competition regulator, recently the Competition Commission undertook study into artificial intelligence. That report has come into public domain recently. The Competition Commission and we as practitioners are examining the same. We expect that that market study report is going to give us better understanding in relation to issues and challenges which flows from the artificial intelligence. Uh, I think last slide I will be able to tell you that while markets differ significantly from one another, the evidence standards are high in all cases. So the challenge remains how to effectively collect evidence, successfully use it in specific cases, and how to interpret and present it before the authority in order for the case to be successful. So at every stage, yes, challenges are there in collection of evidence. Challenge remains how to use it for specific cases, how to interpret it, and how to present it before the regulator so that the order, ultimate order of cease and desist and penalty can be imposed. But last but not the least, as you know, India is a developing country. The basic philosophy is that in case of unilateral conduct inquiries, we need to incentivize the efficiency, we need to incentivize the innovative entity, we need to only such entities which indulge in abusive conduct having appreciable adverse effect on markets or on competition, they should be held accountable and they should be held guilty. Thank you very much.
Thank you very much, Mr. Bhatia. Now we can move on to the next presentation by Ms. Mapato Ramokopa. Ms. Mapato, she's a professional economist with long experience in the field of competition economics, business and economic regulation, and she's currently serving as an economist and an executive manager in the Market Conduct Division at the Competition Commission of South Africa. Floor is yours, Mapato.
Thank you very much, and good afternoon from South Africa. My presentation will briefly cover just some of the provisions of abuse of dominance in our Act, just give you a sense of the South African economy and the tools that we use for investigating unilateral conduct, and then also just in brief deal with our experiences in relation to inspections on abuse of dominance. Thank you. Abuse of dominance in South Africa, it occurs when a dominant company or a group of dominant companies in a market engage in actions that are intended to block competition or remove competition, deter new entrants, and thereby reducing or limiting competition in the market. This conduct is provided for in Section 8 and 9 of the Competition Act, and it includes the following conduct: excessive pricing, engaging in price discrimination, denying competitors access to essential facilities, and we have exclusionary practices like refusal to supply goods, or inducing third parties not to deal with competitors, predatory pricing, and the like. Our Act is unique in the sense that it has consideration for public interest. These are geared at promoting participation of SMMEs and historically disadvantaged firms when we investigate abuse of dominance. So when we look at the effect of the conduct, we have specific provisions that prioritizes these classes of businesses in the assessment. Next slide, please. Just briefly, the context of the South African economy. We have a highly concentrated economy with high barriers to entry, and this is due to the historical exclusion of certain businesses from participation in the market. So what you find is that most of the industries that you have in the economy are highly concentrated. We have low levels of participation in those concentrated sectors, and we may have a number of smaller players, but you'd find that they are fringe and they're struggling to expand and grow in the market, largely because of the barriers to entry and the dominance of some of the firms. Whilst we have a large number of SMMEs, we see that they only contribute about 38% to employment and also about 24% to the taxable firm value. Overall, there are about 294 dominant firms across 31 sectors, and these firms are in critical sectors of the economy such as agriculture, agro-processing, healthcare, and the industrial sectors. So the concentrated nature of the South African economy increases a potential abuse by market participants. And as a result, we do have a number of complaints that come our way dealing with abuse of dominance. Next slide, please. We have a couple of instruments in our toolbox to investigate abuse of dominance. We have targeted information requests to the respondents, but also to the other market players. We also have, sorry, I'm struggling to see. We also have inspections that we would do through a dawn raids. We have interrogations where you would bring in the respondents or market participants. It might not necessarily be your respondents. You bring them, and you have interrogations and where you are able to question them on a number of things, be it the documents that you would have collected and the like. We also do site visits or site inspections. So this is where we would go to the specific firm, or we go to a manufacturing site, for instance, just to get a better sense of the business and how it operates. And some of that information is very useful when we conduct the market definition assessments and to some extent the effects analysis. And where we have challenges in terms of getting information, this is where we also could use the summons, where we would subpoena certain information. Alternatively, we summons information, but we also then can issue summons to have people appear before us for interrogations. Another key tool that we use is advocacy and settlement. This is where we would engage with the parties or the respondents to see if there could be an easier way to resolve the alleged conduct, where we would see if we can find some remedies to the conduct that's been alleged. And at times when we engage in this advocacy, we are able to achieve settlements or undertakings to correct behavior without necessarily having to refer the matter for adjudication. Next slide, please. So just in terms of the inspections, which others term dawn raids, we do have the provisions that deal with a search and warrant activities. So this is where the Act allows us to enter and search the premises broadly. You can search any person with reasonable grounds. You can examine the documents or any articles that you find in the premises. You can also seize those documents that are related to the investigation. You may be able to reproduce records from electronic systems where you may, be allowed to copy the server or the, the hard drives of the respondents' firms and obtain that information. To be able to do a search or an inspection, you need to obtain a warrant if you suspect that a prohibited practice is happening, and if you also believe that the items that you need for your investigation are on the actual premises that you'd be inspecting. Next slide, please. So here, I just want to touch on our experience in inspections for abuse of dominance. We have typically not conducted any dawn raids or inspection in cases of abuse of dominance. And this is really influenced by the complexity of abuse and the extensive and legal analysis that's involved in investigating abuse of dominance. I mean, I think it's Pascalia who mentioned that, you have to collect various pieces of information, put them together, test them for robustness. And sometimes with economic information, you have to rely on assumptions. And then again, that information, it would be very difficult to, for instance, collect in one sitting through an inspection. So the process of collecting information for abuse is an iterative process where you keep on going back time and again to various market participants, even the respondents, just to clarify so that you fit in through the framework of economic analysis or legal analysis that you're pursuing. Dawn raids have been conducted successfully at the Commission. Yes, we have had challenges. But these have largely been on cartel, where you want to quickly seize certain information before it can be destroyed. And such information, it would involve, an agreement between the competing firms, or minutes of meetings, and memorandum of understandings. So that is the direct information that is easy just to read and pick up. Whereas for abuse, it tends to be broader, where you would have to look at strategic information, strategic documents of the firm, economic and financial data from the companies that would be reflective of their business behavior and methods of exploiting the market power or dominance in the market. Next slide, please. So, I mean, I've sort of touched on this a little bit, where, with abuse, you are looking at often more complex long-term commercial strategies, economic data, market analysis, rather than a smoking gun type document or direct communication that you can get when you do a surprise search for a cartel activity. And what usually happens sometimes within the firms that you're investigating, especially big corporate companies, the information or the economic analysis sometimes is even conducted by external economic firms that do not necessarily reside in the same premises as the firms that you're investigating. So you'd find that the documents and some of this commercial information is housed there. So you need to have a very clear strategy of what you need, and who, where, and how you're going to get that information. And inspections in that kind of scenario may prove to be challenging. Also, proving abuse of dominance is much more complex and requires significant legal and economic analysis to show that the dominant firm and its conduct has had a substantial impact on the market, but also that it outweighs any pro-competitive gains. It's much more complex than proving an existence of a per se prohibited cartel agreement, making evidence gathered through a single dawn raid less likely to be sufficient on its own, because you have to piece together different pieces of a puzzle just to make a coherent a theory of abuse. Next slide, please. Look, we have had a poor track record of successfully prosecuting abuse previously, and many of our cases have largely been closed, or we have settled, or they were challenged maybe technically for various reasons. So we have since adopted a much more comprehensive strategy to dealing with abuse. And as I've mentioned, we've got other tools other than just investigation, where we try to collect as much information and see if we'd rather address the conduct and the structural issues that are emerging from the concentrated markets, as opposed to just focusing on one particular agreement that you can just obtain through a raid that might not give you the actual evidence to be able to, apply all of those tools to try and address the market conduct. The other risk that come with inspections or raids would be the legal challenges that it tends to attract. These search warrants can be challenged. If there are weaknesses, maybe there's not enough reasonable grounds to believe that the evidence of a prohibited practice exists in the premises. And we've had scenarios where the High Court has actually set aside the search warrant. So, I mean, as I say, the core focus of the commission is to try and address the structural issues emanating from the concentration. And if there are other means that you can address those without necessarily going and using this complex legal tool, those should be explored. Next slide, please. Just in conclusion, we recognize that conventional enforcement methods such as don't raise can be useful in addressing structural obstacles. We, however, have adopted various tools to address market concentration as well as market power and the unilateral conduct that's resulting from it. To emphasize, market concentration is a structural issue. It demands robust tools that go beyond just the detection of the conduct, whereas with cartels, particularly the per se nature of some cartels, where you just need, one single agreement, the evidence that's required for abuse of dominance is much more complex and such that it needs a number of tools where it can enable you to make credible findings, but also to recommend meaningful structural remedies. And as I've mentioned, the complexity and evidential demands of abuse of dominance require legal and economic evidence. Inspections have not been conducted by the CCSA, but rather we have used largely information requests to obtain information. And where the Commission has experienced difficulties, we've largely used summons and interrogations, and these have been effective. And it's not to say that, parties are always cooperative. You do get respondents that might not cooperate with your investigation, might not respond to information requests. We've had that, and this is where we would then opt for a summons. And largely we have had cooperation once we issue a summons, but we've also had instances where our summons have been challenged. And recently we've had a case where the respondent challenged our summons and the case ended up in the highest court. But fortunately in that instance, we were able to succeed, and the respondent was requested to submit the information. Just to conclude, it's not to say that inspections are not available as a tool to investigate abuse of dominance and unilateral conduct, but the complexity of this conduct and generally the broad success that we've had using other tools, this is why the Commission has not really used this particular tool. Thank you very much.
Thank you very much, Mapato, for your very interesting presentation. Now we're moving on to the last presentation for today by Krishna Tolentino. Krishna is the team lead in the Monopolistic Practices Director at the Canadian Competition Bureau. She's been working in the Bureau since 2016, and she's been working on various unilateral conduct investigations since. She's an economist by training, and we'll hear from her right now. Thank you. Over to you.
Thank you, Vera. I'm happy to cover the last topic for our webinar today, which focuses on the challenges in evidence gathering for unilateral conduct investigations. I think we already heard some of the challenges that our colleagues from other jurisdictions have been observing, but my presentation today would focus on the challenges that arise, particularly from production orders issued by the courts. So next slide, please. So maybe just to set the stage for this, just a brief introduction on the Canadian Competition Bureau. So we are an independent law enforcement agency that's responsible for enforcing the Competition Act. Our role is really that of an enforcer. We don't have decision-making powers. So if we find contravention of the Competition Act, we have to file a case before a specialized court called the Competition Tribunal, and it's really the tribunal that's the main decision making. Our organization is headed by the Commissioner of Competition, and under the Competition Act, the Commissioner has formal information gathering tools. So in particular, Section 11 of the Competition Act allows the Commissioner to apply for a court order. We typically do this before the federal court, so we can compel parties to provide records and information or be subject to oral examinations, particularly if they have relevant records and information to our investigation. But in order to get a Section 11 order, the commissioner must satisfy the court with two things. First is that we should be on an inquiry, or we're in this formal investigation stage. We can't apply for a court order if we are in a preliminary phase of our investigations. And the second element is we need to satisfy the court that the person against whom the order will be issued has or likely to have relevant records and information. Next slide, please. So I'm just going to cover two of the more common issues that we observe in relation to Section 11 orders. These are privilege claims and issues that relate to compliance within the production deadline. So a Section 11 order typically would provide the respondents with the ability to redact portions of a record that's subject to privilege or completely withhold the production of this record. And some of the more common forms of privilege that we see, and I'm sure that other jurisdictions see this as well, are solicitor-client privilege, settlement privilege, and litigation privilege. And the Section 11 orders would also specify the timelines or the deadlines upon which the respondent should produce the records and information to the Competition Bureau. Next slide, please. So just focusing on the privilege claims. So two of the more common issues with privilege claims relates to the overbroad claims of privilege, as well as insufficient information that's provided by the respondent to allow us to assess whether the privilege claim is valid. We've observed in the Bureau that there's this growing concern at the Bureau where we see a large number of relevant records are being subject to privilege claims. We've seen, for example, production orders where upwards of 25% of relevant records are being withheld for privilege. And then if you couple that with, having this insufficient information in their privilege log. So when respondents respond to production orders, there's also instructions to provide an index where they list all the documents that are subject to privilege. They have to provide information such as the author of the document, the recipient of the communication, the type of privilege that's being claimed, and the rationale for that privilege. We've noticed some deficiencies in the privilege log. For example, when respondents claim solicitor-client privilege, for example, sometimes they fail to identify who is the lawyer in that communication, who is the client, and whether it's for the purpose of seeking or providing legal advice. Or there could be instances where litigation privilege is claimed, but then the rationale just says legal information, for example. So it's really like it's not enough for us to be able to assess that the record or the information being withheld is properly subject to privilege. Next slide, please. So then what are the tools that we have to address these issues, right? I think this may be common across jurisdictions, but we have informal and formal measures to approach this. So with the informal measure, this is really a voluntary approach. We work collaboratively with the respondents. We review their privilege log and we identify deficiencies. And then we work with their counsel to address these concerns. I would say that for the most part, in our experience, the voluntary approach resolves a lot of these cases. because parties are willing to provide more information to fill the gaps. But where differences in opinion persists, we have formal measures that the commissioner can rely on, and I listed these measures on the slide here. So one of the things we can rely on are the federal court rules. So through a rule in the federal court, the commissioner can file a motion that may compel the respondent to provide more detailed information to basically fix the deficiencies in their privilege log. And then with respect particularly to solicitor-client privilege, we have Section 19 of the Competition Act that we can rely on. So for this one, the commissioner again may file a motion or an application where a judicial member of the court would review the records that are subject to privilege and make an assessment on whether solicitor-client is being applied appropriately. Another version of that approach would be to have a non-judicial member, like a third-party referee, or that would be tasked to make an initial assessment of whether a solicitor-client privilege is appropriately used, and then where that third-party referee thinks that there are records that are not appropriately subject to privilege, he or she would write a report to the court, and then the court would make a final determination in these cases. There's a bit of a hybrid approach, between, I guess, informal measures. So this is where the commissioner may negotiate on a without prejudice basis with the respondent to agree with them on a process by which we assign a third-party referee or an arbitrator to review the privilege claims, and then we agree on the terms of that process, the deadlines, as well as whether the results of that process would be binding or not. Next slide, please. And then the last thing that I was just going to cover are the issues with production delays. So as I've mentioned, Section 11 orders would include deadlines for production, and through our case law, it's been established that the standard production deadlines are what I listed in the slides here. So 60 days for simple orders, we get 90 days, and in my experience, I've seen 90 days being the predominant production deadlines that's being granted. And then for exceptional, very rare circumstances, the court usually grants 120 days for production. Where the challenge may arise is when parties seek to extend these production deadlines. And the next slide would cover this more. Next slide, please. All right, so when parties seek extensions for production deadlines, they have the tools to do this. Similar to the privilege claims, there's the informal voluntary approach or formal measures, right? So with respect to the voluntary approach, typically they would seek the commissioner's consent to extend the production deadlines, and the commissioner would exercise his discretion on whether to consent or not. Where again differences exist, there are formal tools that parties can rely on to extend their production deadlines. This is through the federal court rules where they can file a motion to vary the terms of the production order. An example that I listed here is recently we've dealt with a motion filed by Amazon Canada. So Amazon, there was a Section 11 order that was issued against it in the summer of this year. The production deadlines in that court order had the standard 90 and 120 days, but Amazon claims that this is not sufficient to comply with the order, so they sought to change that to turn it into a rolling production schedule. So it starts 90 days from the date of issuance to 8 months after the date of issuance of the order. So that was their proposal. The commissioner did not consent to this due to the delays in our investigation. And so Amazon brought a motion. The court heard the motion and made a decision in October of this year. And the decision, they partially granted Amazon Canada's proposal, but they did not grant the 8-month extension. So the rolling production starts at 90 days and ends 5.5 months, as opposed to the 8 months that that Amazon Canada was seeking. This is currently under appeal, so we'll see if the revised or the amendment decision would stand, but it's currently under appeal. Just the last thing, I know we're almost out of time. I just added here a dialogue with respondents, because I think these are important tools that could help mitigate these issues with compliance with production deadlines. So typically before we apply for our Section 11 orders, we share the draft order with the respondent to get their comments and feedback on the burden of the specifications. And typically they use this to also advocate for more time to produce their or to work on their production. So that's one of the engagement with the respondents that we do. Another thing is we also engage in pre-production dialogue. So before the production deadline, we usually do a call with the respondents. This becomes more technical in nature. So we have our people from our evidence handling unit come join these calls so they can talk about the receipt and the sending of the information. And then some respondents also although this is not usually in the Section 11 order, but some respondents typically undertake to produce sample production. Could be like a sample of 50 or 100 documents, just to make sure that there are no technical issues that would arise come production deadline. And I think those are effective tools to mitigate issues with production deadlines. But that's all I was hoping to cover today. Sorry, Vera, there's like 2 minutes left for Q&A, but
no worries, Krishna, that's fine. Thank you very much for all these very rich presentations. We've seen an overview of many aspects that are both from the procedural, also for confronted with the different substantive framework that we have in different authorities. We see that there are, I guess, every authority can see that there are common threads across our experiences. I just would like to open the floor for questions. We don't have a lot of time, but if you want to pose questions. There is a question here. I'm trying to, it's a very long one.
It's for me, I think. Yeah. So
Jonathan, yes, go ahead. Is the question related to when the parties told you that you did not understand the markets, correct? So the question goes, to what extent did you use technical experts in the telecoms investigation that you were talking about? You also mentioned technical questions during meetings. Besides lawyers and economists, did you have technical resources or people to assist you during inspections or meetings?
So I hope now you can hear me. I think there was some issue with the connection. Generally speaking, we rely on ourselves, on our economists and our lawyers to study and get the technicalities of the market as best as we can. In this case, we actually hired a technical expert because we really required the in-depth knowledge of the inner workings of how this industry works. And we contracted a very distinguished engineer who was very a prominent figure in the Ministry of Communications. So somebody who's really an authority in the relevant field, and who actually, if I'm not mistaken, worked for the company in question in the past. So that was very, very helpful. But it's not always easy, and it takes time, and you need to draft, sometimes the contracts and the tenders, and it's complicated. It's a complicated process, but sometimes it's worth it and it's important.
Thank you very much, Jonathan. Then we have a question that I guess is open to everyone, but maybe I would like to Pascal to come in on this. Miguel Odriozola asks, do you agree with the South African presentation in the sense that unilateral conduct cases require more numbers than other cases? It's an open question.
I would say if you compare it to merger cases, I would argue no. Because the reality is that in merger cases, you try all kinds of combination of things. You do, you're basically trying to assess what the future is going to be like. So you need more numbers to predict the future than to look at the past, I would say. Compared to horizontal behavior like cartel cases, of course, more, because cartel cases typically in most jurisdictions are per se. So in fact, the numbers matter very little, right? It's more about who met who, what day, to talk about what. So internal documents of actual exchanges of views. I would say and then you have sort of other types of concerted practice or vertical agreements, for example, where I would say you'd have comparable amount of quantitative evidence as in 102. But maybe the most, I mean, from my perspective, from experience, it can really vary from case to case, because within unilateral conduct cases, you have conducts that are almost per se, right? They just so blatantly locking in the entire market that you don't really need much numbers to, understand what the picture looks like. In other cases where you may have one or two exclusivity agreements, but not in the entire market, and you have the existence of a couple of competitors that may or may not be able to compete on the merits, I think these are the cases where this analysis by effect actually takes much more space, and therefore you do need the numbers to figure out whether you actually believe this is anti-competitive in the end.
Thank you very much, Pascal. Then we have a question to Mr. Bhatia and to Jonathan. Says, documents are key. How do you collect the documents like minutes, emails, and surveys? Do you use raids or is just letters to request these? If you use letters, firms may screen the documents before submitting to the authority. How do you prevent firms from doing that?
Yes, initially we do write letters, and in case the information or minutes or emails are not forthcoming, then the Director General may approach the Chief Metropolitan Magistrate to permit him to seize the electronic records by conducting search and seizure. Other option available is that even after, if the company concerned has destroyed or mutilated the minutes or emails, the emails are generally sent to several parties. Copies are given. So in addition to addressee, there can be CCs or VCC could be there. So DG would like to call those people and cross-examine them. Is it that you received a copy of the minutes? Is it that you received a copy of the email? And they will be examined on oath. In addition to that, minutes are invariably required to be filed with the registrar of companies if those are minutes of the board, if any special resolution has been passed. So the assistance of the Ministry of Corporate Affairs, who is a custodian of all records of the companies concerned, they can be the assistance from the registrar of company, or assistance of public authority can be taken in collection of the documents.
Thank you. Jonathan, maybe you want to come in on this?
Yeah, just very briefly, this is a huge topic that can be discussed for a very long time, but I'll just say this. We invest a lot of time and effort in enforcing responses to RFIs, because we often, unfortunately, quite often, find out that we have companies and persons who fail to respond adequately, and we invest. We take these cases. We don't like taking these cases. We prefer to focus on our, the core infringements of the law, things that relate to competition directly. But since we rely on RFIs, it's very important for us to ensure that we get good responses. Generally speaking, we start with, when we're dealing with administrative enforcement, and from 99% of unilateral conduct cases are enforced through administrative means. we rely on just on RFIs. We do have powers to search and seize, and that is usually when we have a criminal case, usually cartels. But here and there are cases that involve abuse of dominance that at least start with the criminal investigations unit using its real more intrusive powers. So we can discuss this for hours, but I'll stop with this.
Okay, thank you very much. Then we have a question from Vicky Robertson, which is quite technical. She's asking, is the request of specific data sets perhaps prepared for the authority to run computational tools on them, a type of evidence that you would typically request as a competition authority? Would courts in your jurisdiction grant such an RFI? Who wants to take the challenge of this question?
I'm happy to maybe give it a go, Vera. I think
Yes.
maybe you can speak for the Commission on that one. But it's, I think it can be requested, but it's not without strings attached. Because the reality is, if you don't control what is being done computationally, you don't really control the output either. So that's the first one. And the second one is that, I mean, I know that personally, I haven't actually been in a situation where there was contestation of the request, so that we actually had to test whether the party to whom we asked for the processing, that they would actually say no to doing it, and then test whether we would still stand a chance. They've always done it, but the problem is more that they would rather do it the way they think they should be doing it than the way that you would maybe do it if you were the one in the driving seat.
Yeah, maybe I can chip in on this one. So this is like relatively new for us, at least in Digi competition tool that use. I know that it has been used more often in merger cases. This type of analysis. It is hopefully it is a tool that can be indeed used. It can help focusing and reducing the number of documents that is necessary to seize and to hold in our file. We do not have we have an administrative process, so we don't need to ask the courts to grant the RFI. What can happen is that our RFI can be appealed before the court. So such a case has never happened. It could happen. There is a tendency to be much more litigious about RFIs recently, but there is also, we know, everybody knows that there are developments of AI tools that make these type of requests more common and more easy also for companies to comply with. And it's also in the company's interest to apply these tools so that, in the end, what documents have to be handed over to the authority are less. Indeed, there is the challenge of making sure that, what the processing that is being done by the company strictly adheres with the instructions that the authority has given them. But there are mechanisms, I understand, for instance, from our technology advisors, internal technology advisors, that there are tools to make these checks, this control. So I think it's still like it's still work in progress in terms of being deployed in a very broad way, but it's certainly an option that's out there. I think maybe that we have time for one more question and then we can close because the time is running. There is a question. I'm just trying to identify some. There's Edward who has asked a lot of questions, but okay, I see that Krishna has replied already. Sorry, I'm just scrolling down. So there is last question for Mr. Bhatia. Is there any time limit to initiate and to conclude an inquiry in the Indian Competition Act? It's a bit a broader topic. It's not exactly linked to evidence collection. Can you answer in 15 seconds tops?
Yes, 15 seconds. There is no time limit.
Okay, excellent. So thank you very much, everyone, for your lively presentations, for the richness of your presentations. All the slides will be available in the webpage of the Unilateral Conduct Working Group of the ICN. And the recording, as I mentioned at the beginning, the recording of this webinar will also be available. I also would like to let you know that it's just the first step of the work that DigiComp is coordinating within the ICN Unilateral Conduct Working Group on collection of evidence, and there will be different steps as the years in the following years. So stay tuned and follow our work. And thank you very much again. Have a nice rest of the day or evening. Bye bye.
Thank you. Bye bye.
Thank you.
Thank you. Thank you.
Thank you, everyone.
Sir, क्यों आपने इतनी छोटा सा